I just don't understand why I would throw away my judicial release for that.
I don't understand it either, because you weren't real happy with the terms to begin with, so I'm not inclined to believe you when you tell me this, okay? You almost pissed it away before I put you on judicial release. She decides to stick it to you.
I'm still confused about it too. Like I said,
I'm not confused about it, okay, because I don't believe you. You don't have any credibility with me.
Thank you, Your Honor. We're present in case State of Ohio versus Barry Lishing, case number 24 CR 675 and 24 CR 1052, and we are here today on the defendant's motion for judicial release that was filed by Attorney Bill Watson. Thank you.
Mr. Watson.
Thank you, Your Honor. May it please the court. I'll be brief. Mr. Lishing is a drug addict. He had a severe drug problem with the underlying charges in this case, and as a result of that drug problem, he was breaking into cars, stealing items, basically to sell, to pawn, to get money to fund his addiction. This court sentenced him, I believe there were 4 counts. It was 11 months consecutive on each count. He's now spent, I believe, a total of 9 months maybe, between before sentencing and after sentencing. And he's had a lot of time to think and obviously sober up. And Mr. Lishing is a father of 2 young children. He has told me that he is committed to staying sober. He eagerly wants to begin a treatment program if the court will consider this judicial release. I know we've had discussions. We were here previously where my client had refused to cooperate with the NeoCap process. It was reset for today, and in between then, he has in fact met with the intake director and cooperated. I believe he has been accepted there, and I'm going to ask the court to please consider granting this judicial release, give him an opportunity to show this court that he is amenable to community control sanctions and that he will remain sober, and hopefully, I know not immediately, but hopefully, he'll get out and be able to be reunited with his children and show the court that he could be a good father to them too. Thank you, Your Honor.
Mr. Lishing, what do you want to tell me?
So first and foremost, I just want to say I'm greatly appreciative to be here. I know you didn't have to reconsider the judicial when you denied it the first time. I want to say I'm appreciative to you and Mr. Watson. Mr. Watson has gone to bat for me countless times. It didn't have to. And to yourself, I want to look you in your eyes as a man and tell you that I'm grateful for you because you saved my life. I wouldn't be standing here had you not sent me to prison, and I'm sure you probably don't hear this very often, but I'm very appreciative of it. Had you not done that day, I'm almost positive, 95% sure, and giving myself a 5% chance on that is still a stretch, I probably wouldn't be standing here today. I'd probably be dead. I have gone to great lengths to make a change from who I was to where I am now. GED in prison, I'm signed up for the journeyman program to be an electrician, truck driving school, IOP, but the list was extremely long. NA and AA meetings were pretty much non-existent where I was at in Lancaster. They were there, but they were run by inmates, and it just kind of didn't work out the way it should. Church every Sunday. I've done everything I possibly can to show this court that I want to change. I want to be back with my children. And I'm going to do everything I can to go even that step much further to get to where I need to be.
What was the reason that you were resistant when you were here a couple weeks ago about NeoCap?
So when we had a discussion, she asked me what I thought was going to happen. And, and of course I'm not going to say I just gave her, I was trying to have a positive mental attitude when I said, I thought I was going home. And she asked me if I was would consider NeoCap, and when she asked me that, I thought she meant if she asked me if I would consider it over going home. It might have been a miscommunication, so I take full responsibility for that. That was my fault. I didn't mean to, I wasn't resisting. It's just I kind of, I don't know. I just misunderstood what she said.
All right, anything else?
Other than that, I've been going to great lengths to keep in contact with the people outside. Multiple different programs, on top of, I have everything set up to finish taking my GD classes. Everything I can possibly do to, once I get outside, to continue doing what I'm supposed to be doing, regardless of any interference, whatever. I'm mainly focused on putting my whole life back together. My children need me, my family needs me, and I right now I'm so disappointed with myself that I've left my children out there to pretty much be with their grandmother, and it's time for a change. It's time to go back to what I was doing.
All right, Ms. Wood?
Thank you, Your Honor. The state does not object to the defendant's motion. I think the NeoCap program would be appropriate for him prior to releasing him back into the community. We would just ask that a no contact order be ordered by this court in both cases for all of the victims listed in the indictment. And in case number 24 CR 1052, the victim's name is Kenneth Kropak, Kropac. Thank you.
All right, Ms. Henley, anything you want to say?
Yes, sir. I was taking a closer look at the defendant's ISR, and it did note a hold for Cuyahoga County, so I just wanted to make sure the court was aware that the defendant does still have the active warrant in Cuyahoga County for a probation violation, which may complicate matters for NeoCap.
From 21? Yeah, 21 keys.
Yes, sir.
Okay.
A 22 case, Your Honor.
Yeah, okay. All right. I'm going to grant your motion. I'll place you on community control for 4 years. You'll serve 60 more days in the jail. Or 45 more days in the jail. The last 30 are going to be in the jail treatment program. Complete that, follow the recommendations. Then you're going to go to NeoCap, complete that program, follow the recommendations. No drugs or alcohol with screens. You're to go to only one doctor and one dentist and one pharmacy for any prescription medication. Take your medication as it's prescribed. Sign releases for probation. Attend at least 3 AA or NA meetings a week and get a sponsor. Get a valid driver's license. There was a restitution order to Kropak in the amount of $594.99. Also, no contact with any of the victims in this case. And pay the costs and supervision fees. Any other terms, Ms. Henley?
No,
Who will his PO be? Do you know?
Kim Ramos.
Okay.
If Mr. Lishing still lives in Gainesville, yes.
All right, understand everything, Mr. Lishing?
Yes, sir.
All right, if you violate, you gotta go back.
I don't want to go back.
All right, I'm gonna attempt to call that judge in Cuyahoga, let him know what's going on here and what we can do to get that thing dealt with the easiest way possible. Anything else, Ms. Wood?
Is the order for 45 days in jail on both case numbers?
Yeah.
Okay.
Mr. Watson.
Nothing further, Your Honor.
Okay, that's it. All right. Seated. All right, we're here on 24-675, 24-1052, Barry Lishing. Violation of community control. Violation is you were denied entry into the jail treatment program due to statements made to Lawrence Spector. Do you understand that allegation?
Yes, sir.
Mr. Mulkey?
Yes, Your Honor, I conferenced with my client regarding the probation violation in these matters, explained to him his right to probable cause hearing and a full and final dispositional hearing on this matter. He's indicated to me, Your Honor, he certainly would waive the initial probable cause hearing. I also believe he would waive the final dispositional hearing. He'd like to resolve this case one way or the other today, if that is possible, Your Honor. Thank you.
Is that what you want to do?
Yes, sir.
All right, what's your plea to the violation?
Guilty.
What?
Guilty.
All right, I'll accept your guilty plea and find you guilty. So, I sentence you to prison in October 2nd of '24 on these two cases. And I made a note that I was going to put you on judicial release at a certain point, and I did that when you were here on July 10. And the terms of your probation were 45 days and additional 45 days, with the last 30 being in the jail treatment program, followed by NeoCap with some other terms and conditions. And if my recollection serves me correct, you weren't particularly happy with those two aspects of your community control. But we got through that hearing, and then I hear these reports in July when you're being processed for the jail treatment program that you're indicating to Ms. Spector you're not going to go on the range where the jail treatment program is. You're going to go stay in your cell and go back and forth. And Ms. Spector tells you that that's not how it's done. And you say, well, other inmates are allowed to do it. Why can't I do it? And she said you can't do it, and then at some point you called her a bitch. So that's why we're here for the probation violation. So why did all that happen?
So I did ask to stay in my cell, to not go to do the classes from my cell, to go back and forth. She had indicated to me that she would talk to her team and see what they could do. So when she came back, she was accompanied by CO Roba, standing at the door with her when we had our conversation. She told me, when she came in, she's like, you're gonna go down there, you refuse, because that's not how we do it. Now, yes, I questioned it, because I've seen other inmates do it, and me being from prison, I was trying to avoid, conflicts or any issue that would cause me to go back to prison down in the range. Now, we had a few questions back and forth. I asked to speak to the head person of the JTP, which she refused to do that. After a certain point, I was like, I'll go down there. I'm not refusing. But if something happens, I tried to avoid this. This isn't on me. She immediately said that this is a threat, threw up her hands. This is in front of a CO. The CO was well aware of what was going on. There was no threat ever made. I never called her I'm not gonna say the word, but I never called her that word. Had I done that, I would have been in the hole immediately. There's no report of it, nothing of that. I've never done it. I just don't understand why I would throw away my judicial release for that.
I don't understand it either, because you weren't real happy with the terms to begin with, so I'm not inclined to believe you when you tell me this, okay? You almost pissed it away before I put you on judicial release on July 10th. Because you were given an ass ache about the terms, okay?
Mhm.
So, I mean, that very nearly didn't go through because of the attitude that you had, okay? So now I'm supposed to believe that the person that's been running this thing without an issue with other inmates, all of a sudden is telling a tall tale as to you. Why does she hate you all of a sudden?
Like I said, I have COs that were standing there that would tell you that I never made the threat. I never said that to her.
Okay.
There's no reason for me to throw away my judicial release.
I'm just trying to figure out at this point why she's lying about all this. Why she's out to get you all of a sudden. You don't know?
I have no idea.
Okay.
I said, I mean, we did have an argument over it, but it was never a threat.
Why do you think you're in a position to get into an argument with the person that runs the program?
I simply just asked to stay in my cell.
Well, you called it an argument, now it's a calm conversation. So you just had a calm conversation with her, and all of a sudden, she decides to stick it to you.
I'm still confused about it too. Like I said,
I'm not confused about it, okay, because I don't believe you. You don't have any credibility with me. Okay, so I believe that exactly what she said is exactly what occurred and that you called her a bitch, okay? So where do we go from here?
I mean, really, I'm not trying to duck the treatment. I've never tried to avoid
You tried to
it.
duck it on July 10th when I put you in it. You wanted to get out and do IOP.
No, I wanted to go to New Day Recovery. I wanted to go to a full
Okay,
program.
whatever, okay. You wanted to do what you wanted to do, and I didn't go along with it, okay? And you weren't happy about it. And that continued for another couple of weeks until you were interviewed for the jail treatment, and you weren't happy about it. You let that be known, okay? So you want to do what Barry wants to do the way he wants to do it. And what makes you think you're in that position to do that?
I'm absolutely not.
I mean, you don't have a great track record of doing what's best for Barry, okay? If you did, you wouldn't be sitting here right now, right?
Yes, sir.
Okay. So why don't you kind of surrender your thoughts as to what's best for Barry when you don't know what's best for Barry?
I mean, I really don't know what to say at this point. All I can do is say that I'm willing to do whatever you want me to do to try. Like I'm not gonna fight it anymore.
Okay. You should be almost done with jail treatment by now. Okay. So I don't know why you pissed away 45 days for nothing, other than you're a hardhead. So what do you want me to do? What do you want me to do?
I just want a fair chance to succeed.
Okay. Well, I gave you a fair chance to succeed. And you decided you wanted something different. You wanted it on your terms, when you're not in a position to dictate terms. Sit down. We're beyond the 45 days at this point. We're at like day 47. should be in Warren right now. Mr. Mulkey, anything you want to say?
Your Honor, on behalf of my client, I believe that he is now in a place where he understands what is expected of him. He's very high on this court's radar in terms of his cooperation. Your Honor, he's got to make this change within himself and stop fighting the requests that he's been, or the orders even rather, that he's been asked to do, because after this, from my understanding, is he's got NeoCap that he's got to also make it through. So this is just the first step. So we're not off to a very good start, Your Honor, but I think he would like to rectify that situation and demonstrate to the court that he can do that without further incident. Your Honor, thank you.
All right, I gave you, back in October of 24, 48 months. You had done 6 of it already, so 42 months, and now you're up to another few months. I don't know. I mean, time doesn't seem to matter to you, but I guess we'll find out what happens. You're gonna get another 45 days in jail from today. The last 30 will be in the jail treatment program. So it's the same terms as we went through on July 10. And for whatever reason, you just pissed away 47 days, okay? So you go over there and either do the program or don't do the program, all right? Do whatever you want to do. And then based on what you decide you want to do, then I'll decide what I have to do. You understand?
Yes, sir.
Mr. Mulkey, anything else?
Not at all, Your Honor.
Ms.
Thank you.
Randallson, anything else?
No, Your Honor.
All right. All right, give me another shot. Try to make it work.
Yes.
Okay.
Seated, Ms. Mulligan.
Your Honor, we're here in the matter of the state of Ohio versus Ernest A. Fuller Jr. This is case 24 CR 1382. Mr. Fuller is present in court. He is accompanied by his attorney, Ms. Nicolette Tomasic. He was last before the court when he entered a plea of guilty to 1 count of having a weapon under a disability felony of the 3rd degree. The court ordered a pre-sentence investigation report at the time of the plea, and that has been accomplished, and we're here today for sentencing.
Ms. Tomasic?
Yes, thank you, Your Honor. We would like to ask the court today to allow Mr. Fuller an opportunity on community control sanctions, or in the alternative, if the court does not see that probation would be fit, then the minimum prison sentence stay, Your Honor. In speaking with Mr. Fuller and in reviewing the initial competency report, it is clear that Mr. Fuller does suffer from some mental health issues. In speaking with Mr. Fuller, he is aware of his mental health issues. I know he's been on probation with this court before and has been monitored before, so we would like to ask the court for an opportunity. In speaking with Mr. Fuller's significant other, Angelica, she's in the courtroom today. She indicated that at a period of time, Mr. Fuller was taking his medication, and when he does take his medication, he is very good and on track. He also does have a 6-month-old baby that he does take care of full time because his significant other does work. So we'd just like to ask the court for an opportunity for Mr. Fuller to be put on probation, monitor his mental health, see if we can get him some sort of assistance with taking medication and keeping track of his mental health. Like I said, Your Honor, if probation is not fit, we would at least ask for the minimum prison sentence. Thank you.
Mr. Fuller, what do you want to tell me before I impose sentence?
You gotta understand the charges on the behalf of me that I show ownership by pleading guilty, knowing what was going on the scene of the incident when we got pulled over, knowing what's going on in the courthouse, and knowing that I wasn't supposed to have no gun, other weapons on disability when I'm a convicted felon. I just wanna say I just show ownership of the charge that it was supposed on me and just hope for the best outcome.
PSR indicates as a juvenile assault and attempted felonious assault. As an adult, May of 16, a domestic violence. June, obstructing official business. June, criminal trespass. September, assault. Then in June of 16, trafficking cocaine, which came here. I put you on probation. Jail treatment program, thinking for a change program, meetings. That was June 21 of 17. Probation violation in 19 for, or 18 for marijuana use. June of 19, another trafficking in cocaine offense. Kept you on probation. Violation in 20 with the weapons under disability and improper handling. Kept you on probation. Trafficking in cocaine, kept you on probation. All that time that you were on probation, we had a lot of contact through hearings, through informal hearings with Kim Randallson. In a time when you probably shouldn't have been kept on probation. You did well for a period of time, and you did well when you worked at it, and you addressed your mental health, and you stopped the drug use, and then you would get back to your old ways, and then you were doing okay for a period of time, and then you get an attempted domestic violence, a felony 5 in January of, or May of 22. Gave you 8 months in prison for that. With a lot of credit, you did a month and a half. Then you get this one in November of 24. In the meantime, you got a disorderly out of the Hillcrest Hospital. And then there's a pending felonious. I don't know what that's all about or where that's going, but that doesn't matter for the purpose of this case. So you've had many opportunities. You've had many more opportunities than other people would get, and you haven't seen fit to do what you have to do. And you can do what you have to do, you just didn't want to do it. So I've considered the pre-sentence report and what you've said, what counsel has said, considered all the provisions in 29, 29, 11, 12, and 13. And so at this point, I'm going to find you're not amenable to community control. I'm going to sentence you to 18 months in prison with credit for 54 days. When you get out, you might be on post-release control for up to 2 years under the parole authority with conditions. If you violate, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. If If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which would be the greater of 12 months of the time left under post-release control. Anything else, Ms. Mulligan?
No, Your Honor, thank you.
Ms. Tomasic?
No, Your Honor, thank you.
Thank you, Your Honor. We are hearing case 25 CR 949, State of Ohio versus Matthew T. Dunlap. Present in court is a defendant who's accompanied by his attorney, Mr. William Watson. We are here on a 2-count indictment filed August 1st, 2025. Those counts being count 1, obstructing official business, a felony of the 5th degree, and count 2, resisting arrest, a misdemeanor of the 1st degree. It is the state's understanding that the defendant is prepared to withdraw his previously entered plea of not guilty and enter a plea to count 1, obstructing official business, a felony of the 5th degree. The state would join in a recommendation for community control sanctions and would also request a pre-sentence investigation report and victim impact statement. Thank you, Your Honor.
All right. Mr. Watson?
Thank you, Your Honor. May it please the court, that's my understanding of this afternoon's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I believe full discovery has been provided. I've also had an opportunity to discuss this matter with Mr. Dunlap. He has indicated he is prepared to enter a change of plea as just outlined. He understands that by doing so, he'll be waiving certain constitutional rights. No threats or promises have been made in order for him to do so, Your Honor. And I would just respectfully like to add, in addition to the pre-sentence report, we would also like a drug and alcohol assessment. Thank you, Your Honor.
All right. Mr. Dunlap, how old are you?
38, Your Honor.
How far did you go through school?
I graduated high school and went to a trade school.
Are you a U.S. citizen?
Yes.
Be able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
Anxiety, depression?
Are you being treated for that right now?
No.
All right. Did you get a copy of this indictment?
Yes.
It's my understanding you're going to plead guilty to count 1, obstructing official business, of felony 5, and then count 2 would be dismissed. Is that your understanding?
Yes.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question or you want to talk some more to Mr. Watson, let me know. I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt in a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
I mean, yes.
What's the question you have?
I mean, if I do go to trial and I do want to appeal, I'm not going to go to trial, but I mean, I'll just say yes.
Okay. Well, there's still a question in your mind, so what's the question?
I mean, could you repeat the question?
Yeah. I'm in the process of going over all the rights you have for a trial, okay? If you want to plead guilty, you have to acknowledge
I
that
have to
these.
waive all the rights?
You have to acknowledge that you understand these rights, and then you have to specifically waive those rights. So
Okay,
that's why
yeah,
I'm going
all
through
right,
these
I under-
questions.
Okay, you explained it a little better.
All right, so the last question was if you were to file, if you go to trial and you get convicted, you have a right to appeal, and if you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. So do you understand that right?
Yes.
And are you gonna waive that right?
Yes,
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
yes,
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
yes,
Are you waiving that right?
yes,
And if you could not afford a copy of those transcripts, they would be given to you at no cost. Do you understand that?
yes,
All right. If you plead guilty today, you do not have the right to appeal the guilty finding. Do you understand that?
yes.
All right. Do you have any questions about any of those rights?
No, Your Honor.
Do you still want to plead guilty to count one?
Yes,
Do you understand that by pleading guilty, you're fully admitting your guilt to the charge?
yes,
Do you understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time that I could sentence you to prison, to jail, or to community control?
yes,
All right, obstructing official business in count one is a felony 5. It carries a maximum prison sentence of 12 months and a maximum fine of $2,500. Do you understand that?
yes,
Are you presently on post-release control to the parole authority?
no, sir.
Do you understand that if a prison term is imposed in this case, that you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yeah,
If you are placed on post-release control and you violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
yes,
Do you understand that if the violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for that violation?
yes,
And if that were to occur, the maximum prison sentence for that violation would be either 12 months or the time left under post-release control, whichever is greater. Do you understand that?
yes,
Do you understand that if a prison term is imposed, you are eligible for judicial release?
yes,
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. Do you understand that?
yes, Your Honor.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No,
Has anybody promised you what I will sentence you to in this case?
no, sir.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer at the time of sentencing?
Yes,
Have you had enough time to talk to Mr. Watson before pleading guilty today?
yes, I did.
Has he discussed everything about your case and answered all of your questions?
Yeah,
Are you satisfied with the advice he has given you?
yeah,
Have you been threatened or coerced in any way to plead guilty today?
no,
Are you freely, knowingly, and voluntarily entering your guilty plea?
yes,
Do you have any questions?
no, sir.
All right, Ms. Himmeline, if the case went to trial, what would the evidence show?
Thank you, Your Honor. The case went to trial. The state would prove beyond a reasonable doubt that on June 21st, 2025, in the city of Mentor, Lake County, Ohio, Mentor police were alerted by Flock that Matthew Dunlap's vehicle was in the city, and they were alerted because the defendant had a warrant. Officer Province located the defendant's vehicle and observed the defendant exit the driver's side. Officer Province asked the defendant if he was Matthew Dunlap, and he said no, and at that point he ran away from Officer Province, who had to tackle the defendant in order to place him under arrest. As a result of that tackle, Officer Province tore his PCL, required surgery, and has been out on medical leave since that time. Thank you, Your Honor.
All right, Mr. Watson, anything to add to those facts?
No, Your Honor.
Mr. Dunlap, did you hear what Ms. Himmeline said, that the facts would show if the case went to a trial?
Yes, Your Honor.
And are those facts true?
Yes,
What is your plea to count one, obstructing official business, a felony 5?
guilty, Your Honor.
All right, Mr. Watson?
Just sign it now. It's the same form I went over with you. No changes to it at all. So I need you to sign right there. I know it's a little tough. And today is 8/26/25.
Your Honor, I witnessed the defendant sign the written plea of guilty and judgment entry of the court, and it's also been signed by Attorney Watson and myself.
Mr. Dunlap, is this your signature on this written plea of
Yes, Your
guilty?
Honor, it is.
Did you sign it voluntarily?
Yes,
Do you want me to accept your written plea of guilty?
yes.
I'll accept the written plea of guilty. Defendant was present with Mr. Watson. Advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept his plea of guilty and find him guilty of obstructing official business of felony 5. I'm going to refer this for a pre-sentence report, drug and alcohol evaluation, victim impact statement. Sentencing will be October 1 at 9 a.m. The bond is continued. Anything else, Ms. Himmeline?
No, Your Honor.
Mr. Watson?
Nothing further, Your Honor.
All right, we're adjourned.
Now, I have to stand up, stand by.
Your Honor, we're here in the matter of the State of Ohio versus Kenneth L. King. This is case 25 CR 1023. Mr. King is present in court. He's accompanied by his attorney, Mr. Chad Mulkey. The state has entered into an agreement with the defendant through counsel, and it's my understanding that Mr. King is prepared to waive his right to have the investigation conducted by the Willoughby Hills Police Department presented to the grand jury and proceed by way of an information. The state has filed an information charging him with 1 count of attempted having a weapon under disability, a felony of the 4th degree. I understand that he is prepared to tender a plea of guilty as charged, and the state would be recommending a community control sanction.
Thank you, Mr. Mulkey.
That's all accurate, Your Honor. My client is competent to go forward today, so we are anticipating a plea to that information. I did go over that offer with them. Thank you.
Okay, Mr. King, how old are you?
I'm 20, I mean, no, not 20, 56.
All right, you can have a seat.
He is competent, Judge. Just want to restate that.
All right, how far did you go through school?
12th grade.
Are you a U.S. citizen?
Yes,
Are
Your
you
Honor.
able to read, write, and understand the English language?
Yes,
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
no,
Have you ever been diagnosed with or treated for any mental illness?
yes.
What have you been diagnosed with?
Bipolar schizophrenic,
And when were you diagnosed with that?
6 years ago.
Are you being treated for that?
Yes, Your Honor.
And do you get prescribed medication for it?
Yes, Your Honor.
What do you
Judge.
take?
I don't know the names, but it's 8 types of medications.
When's the last time you took anything?
Day before yesterday.
All right, does that, the fact that you took that, does that affect your ability to understand what's going on here?
No,
Okay, did you get a copy of the charge that was filed here?
no, Your Honor. This one.
Right here, the information. It's the attempted weapons under disability charge.
Yes,
It's my understanding you're going to plead guilty to that charge?
yes, Your Honorable Judge.
Do you understand that you have the right to have the case presented to the grand jury for them to decide whether or not to indict you?
I agree, Your Honor.
Did you discuss that right with Mr. Mulkey?
Yes, I did, Your
And
Honor.
are you going to waive that right?
Yes, yes.
Okay. Go ahead, Chad.
Yeah, just for the record, he actually already signed it. If it's all right with the court, I'd like to just have him initial.
Yeah, have him initial.
Yeah. Go ahead, just put your initials next to your name.
Your Honor, I witnessed Mr. King acknowledge his signature on the waiver of indictment form.
All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, then stop me. Or if you want to talk to Mr. Mulkey, some more, let me know that, and I'll let you talk to him for whatever time you need. Do you understand that?
I understand, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Understand.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand that the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Understand.
After the witnesses are done testifying for the prosecutor, then you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Understand, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Understand.
Are you waiving that right?
Yes, Your Honor.
If those witnesses refuse to come to court, then I'll issue an order called a subpoena to make them come and testify. Do you understand that?
Understand, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Understand.
Are you waiving that right?
Yes, Your Honor.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Understand.
Are you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Understand.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Understand.
Are you waiving that right?
Yes, Your Honor.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Understand.
Are you waiving that right?
Yes, Your Honor.
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Understand, Your Honor.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Understand.
Are you waiving that right?
Yes, Your Honor.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Understand.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Understand.
Do you have any questions about any of your rights?
No, Your Honorable Judge.
Do you still want to plead guilty to this charge?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Understand.
Do you understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time that I could sentence you to prison, to jail, or to community control?
Understood.
The attempted having weapons under a disability is a felony of the 4th degree. It carries a maximum prison sentence of 18 months and a maximum fine of $5,000. Do you understand that?
Understand.
Do you understand that your felony conviction prevents you from owning or possessing a firearm?
Understand.
Do you understand that if a prison term is imposed in this case, as part of your sentence, you might have to serve a period of post-release control for up to 2 years under the parole authority?
Understand.
If you are placed on post-release control and you violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Understand.
Do you understand that if your violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for the violation?
Understand.
If that were to happen, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Understand.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Understand.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 18 months. Do you understand that?
Understood.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, Your Honor.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Understood.
Have you had enough time to talk with Mr. Mulkey before pleading guilty today?
Yes, Your Honor.
Has he discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice he has given you?
Very much, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
Oh, no, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, Your Honor.
Do you have any questions?
No, Your Honorable Judge O'Donnell.
All right. Mr. Mulligan, if this case went to trial, what would the evidence show?
Your Honor, the state would be prepared to show that on July 5th, 2025, in Willoughby Hills, Lake County, Ohio, the defendant had in his possession an operable firearm. This was discovered during an encounter with Willoughby Hills police officer where he voluntarily surrendered the weapon to the officer. Mr. King had previously been convicted of felony drug offenses at the Cuyahoga County Common Pleas Court in 1993 and in 2002.
$1993, it's 32 years ago. That was before you were born, because you're only 26. All right. Mr. Mulkey, anything to add to those facts?
No, Your Honor.
All right, Mr. King, did you hear what Ms. Mulligan said, that the facts would show if the case went to a trial?
Yes, understood.
And are those facts true?
Correct.
All right, what is your plea to attempted having weapons under disability, a felony for?
Guilty.
All right, Mr. Mulkey.
Thank you, Your Honor. Fold it over, so you're gonna sign this now, okay? And you are a citizen of the United States, correct? Correct. All right, go ahead and sign there. And just put 8/26/25.
Your Honor, Mr. King has signed the written plea of guilty. His signature will be witnessed by counsel.
All right, Mr. King, is this your signature on this written plea of guilty?
Yes, Your Honor.
And did you sign it voluntarily?
No, sir, Your Honorable Judge.
You
Did
did.
you
Oh,
sign?
yes, 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 I did, yes, I did.
All right, and do you want me to accept your written plea of guilty?
Yes, Your Honor.
All right, I'll accept the written plea of guilty. The defendant was present with Mr. Mulkey, advised of all of his rights, made a knowing, intelligent, and voluntary waiver of those rights. He understands the nature of the charge, consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept this plea of guilty and find him guilty of attempted having weapons under disability, a felony 4. I'll refer this for a pre-sentence report and a psychological evaluation. Sentencing will be October 1 at 2 p.m. and the bond is continued. Anything else, Mr. Mulkey?
Drug and alcohol evaluation, Judge?
That'll be part of the overall psych.
Very good. Nothing further, Your Honor.
All right, now, what about this positive on the medical marijuana thing?
Your Honor, my client informed me that he will test positive for marijuana today. He indicated it's for medicinal use, and he further indicated that it is prescribed by his doctor. I admonished him to not use marijuana. He did sign his bond conditions form. I specifically pointed out that
Right.
bond condition to him.
So the bond will remain in place. I'm assuming that it'll test positive, but don't use the medical marijuana prescription, it's not a prescription, the recommendation that you got, okay?
Understood.
All right, anything else?
No, Your Honor, thank you.
No, Your Honor, thank
Okay.
you.